The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Good morning. The
Morning.
COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning and recording will be available later today. We're ready to hear argument in cause number PD-1053-19, Allen Bray Pugh versus the state of Texas. You may proceed.
May it please the court. Learned counsel, thank you for the opportunity to be heard. Good trial lawyers use visual aids. They're important and they influence juries. Acknowledging that fact and acknowledging the nuance and the complexity of human behavior, this and other courts have counseled extreme caution in their admission, especially when human action is depicted. Y'all have acknowledged that human behavior is just too nuanced and complex to recreate except by videotape. In Miller v. State, quoted in my brief, y'all have acknowledged the impossibility to duplicate every minute detail and the inherently dangerous nature of such recreations, and that they are often too highly prejudicial to ensure the state or the defendant a fair trial. That's a powerful denunciation, if not an outright prescription.
Counsel, what are you taking issue with any of the calculations on how the accident occurred, or is it just that it's not allowing for the behavior of the defendant and the knife in his hand in the exhibit that you're taking issue with?
Yes, Your Honor, you've hit it exactly. That is exactly my argument. I'm not questioning. I'm sorry.
Okay. So
I'm not questioning Mr. Kropp on the X's and O's and all that. I'm just questioning on the depiction of the decedent as unarmed and stationary, which of course goes to the core of a self-defense / murder case.
Sure. Do you think though that under this, if we agree with you, does that mean that for an accident diagram with a pedestrian that we're going to have to draw, say, a knife on the diagram in order to make it a demonstrative exhibit? Or is it what level of resolution are we talking about where you then have to start adding these things?
Well, sir, I would argue that based on Miller and its progeny, really it should be very rare that such a recreation is allowed. And if it is allowed, Mr. Probst made a good point when we were preparing. Perhaps you could depict the person as an X or just something less suggestive than an unarmed human form.
Well, excuse me, counsel, you cite Miller. That was decided over 30 years ago, and I think the part that you're talking about is dicta in that case anyway. I mean, I don't think it was necessary to the resolution of the case. And I think what you're talking about here, if there is inconsistency in what they brought, you cross-examine the sponsoring witness about every inconsistency, every assumption, every inaccuracy in the animation, and that could work in the appellant's favor, making it seem though the state was trying to mislead the jury. But here, I don't see, at least in this case, they're not presenting any scenes of criminal activity or anything like that. They're just showing measurements and things of that nature, which, I don't know. Perhaps you can show me where that has really prejudiced the defendant or the appellant, but I can't, I'm having a hard time seeing that.
Well, that's an intelligent point, Your Honor. But I would say that just having three animations, where a person who wears, the dual cloaks of authority of police officer and purported expert, depicting that is seen as unarmed and stationary, that's just powerful stuff. And this court, in dicta, albeit, noted how powerful that is. But look at Hamilton, also cited in my brief, for a well-reasoned opinion by the Amarillo Court of Appeals.
I agree with you, counsel, that if you have a really dramatic depiction, that could possibly rise to some level of, look, I'm going to have a heart attack. I apologize. My face gets red if I lean over here because of my camera. So it's not that I have a heart condition. But I would say that, like, the point you're saying is that you could have an X and that would accomplish the same goal. But that's just a matter of how detailed the demonstration is. It's like, if you have a photorealistic demonstration, I can see how you might say, well, this could indelibly impress upon the jury that this is the way it really happened. But I've looked at the videos; they look like they're on a Nintendo Switch, not like a PS4.
And that does matter to the calculus of whether or not it prejudiced Mr. Pugh, certainly. But again, it was just, as my brief indicates, it was really so unnecessary. Mr. Kropp proffered the exhibit to show that Pugh was able to negotiate obstacles and accelerate it going up to De Lorme. Again, that was 12 people of average intelligence could have gotten that from the testimony and from the photos of the
so
scene.
unnecessary is not the test, is it?
I'm terribly sorry.
I said so unnecessary is not the test. That's not the question or the answer.
I would respectfully say that it factors into it. Why present three, given how much influence visual aids do have on jurors? Why put them in? Why put them in if they don't aid the jury?
It wasn't this case was tried in front of Judge Edson, wasn't it?
Yes, sir.
And he did exclude some of the proffered testimony. Some of the videos and what have you, and let in these after considering them and considering the arguments. Isn't that correct?
Yes, sir. He omitted the Pugh first person video. Mm-hmm. Yes, sir.
Yeah.
And then he allowed the other three.
He's a pretty careful judge.
He knows what he's doing. He was a prosecutor 30 years. Yeah. Absolutely.
Oh yeah. The DA and Abilene. Yeah.
Can you hear me?
Yes, Your Honor.
How much notice did the defense have that this particular video was going to be offered in the course of the trial?
That I don't know, sir. I'm sorry. I don't think that ever came up.
Well, I'm wondering whether, just hypothetically speaking, if I understand that it's your position that the video should not have been admitted, period. But in another factual scenario where this same video was intended to be introduced and notice was given to the defense, and the defense was given time or an opportunity to produce its own competing video, what about a set of circumstances like that? What would your opinion be under those circumstances?
Well, that could certainly mitigate things. Certainly. Again, though, it's hard for me to get over just the concept that a picture is worth 1,000 words, and the visual appeals to a jury at such a visceral level.
Sure,
that,
counsel, I agree with you in that regard, but you're also talking about an exhibit where if you looked at the animation, the knife would be like this big. I don't see that adding the knife would have actually necessarily changed the impact of the video either, because you have this relatively slow motion thing that isn't terribly compelling. It looks conceptual, is kind of the thing I was getting at with regard to the level of resolution and photorealism. That doesn't look as clinical, but this looks very clinical. And so I don't see why there needs to be this knife or the running around. What would he have done?
Well, that goes to my point. I would respectfully assert he shouldn't have done it. That's my basic argument. Under the facts of this case, he shouldn't have done it. Is basically my argument.
That's okay. So did the testimony that there was a knife found come from any of these experts that introduced the video?
No, the evidence of the knife would be Pugh's testimony, the evidence of Delarmay's aggression, and the fact that it was found apart from his person in the parking lot, suggesting that it was being wielded rather than sheathed at the time of the impact.
Counsel,
Yes, ma'am.
was there anyone besides the appellant who testified that they saw the victim wielding the knife and lunging towards the vehicle?
No, ma'am. I think they had departed by then. Just the evidence was they saw his companion before he departed the scene, saw him approaching quickly toward the scene. And then again, just the other evidence I've found. But of course, the fact that Pugh might be disbelieved does not constitute affirmative evidence that Delarmay was in fact unarmed and stationary.
Sure, but then my question is, when these animations were shown, did defense trial counsel then cross-examine about the knife and Mr. Pugh's testimony that the victim was lunging at the vehicle, wielding a knife, or was there any cross-examination as to that?
I don't remember. Nothing particularly that stands out in my mind. And I agree with you that there probably should have been, and that's not before this court. But and you're right, that would have been a vehicle for the defense counsel to have mitigated its impact. You are right about that.
But there was testimony about the knife in the bar before whatever happened outside occurred, correct?
Yes, ma'am.
Yes, there was testimony that Delarme had earlier pulled out a knife, threatened the bartender, and that the appellant and his friends had intervened. I mean, that was before the jury, and I know Judge Edson excluded a bunch of evidence clips that showed some of the action, didn't he? At the defense instance.
You mean some photographs?
No, I think there were some clips that the state had tried to video clips that the state had tried to offer that he excluded.
I'm sorry, Your Honor. The only thing I remember is the first person view of Pugh. I may be mistaken, but that's the only thing I recall in my preparation.
But he did exclude that.
And
Oh, yes, sir.
And importantly, the bartender testified that he heard the appellant say something along the lines, if he tries to pull the knife again, we'll put him under the car.
Yeah.
Yes, ma'am.
Yeah. So, I mean, there's no question, but there was evidence before the jury, believable evidence from that he had a knife.
Yes, sir. Yes, sir.
Okay.
And there was evidence that the knife was found at the scene close to the body, right?
Sure.
Yes, sir.
Which is one of the reasons I was asking about whether these accident reconstruction experts or any of these experts had said or testified that the knife was found, because that's not something you see on the video, that a knife was found. So in that sense, there is a differentiation between what their testimony was and what the video was. So I just was wondering if there was any testimony of that from them or not. If there wasn't, then I don't see why you would even need to have the knife in the video.
I don't think that, I'm not sure if they addressed, I know they testified that the knife was found in the parking lot. I mean, we have a photograph of it found in the parking lot apart from Delarmay's person. And again, I'm going back to the fact that, yes, the jury did hear things that contradicted what Croft said, and that mitigates the damage of what he does. But our contention is, under the facts of this case, at the end of the day, these, three animations, again, visual aids being as powerful as they are in influencing a jury from someone who's both an expert and a cop. We would argue that under the facts of this case, given how patently unnecessary it was, that it prejudiced Pugh.
What makes something prejudiced? Like, what is the prejudice? What are we looking at? I mean, is it prejudice because it just makes him look guilty, or is it prejudice because it tends to draw the jury's attention away from the evidence? What makes it prejudiced?
I think both. I mean, here, of course, in a case like this, whether the victim was approaching and armed or whether he was unarmed and stationary, goes to the very core issue of self-defense. And for the jury to just see a depiction of a knife-wielding aggressor, at least there's some evidence of that, being depicted as a passive victim, in human form, albeit a crude form, as you have aptly pointed out, That's just powerful. I mean, I'm technologically challenged. You'll notice that there's no Court of Criminal Appeals background on my wall, and I tried for an hour. And even I, as a technological retard, try to incorporate visual aids in the cases I try. They matter. This is a cop. Juries respect cops. This is an accident reconstructionist. And him depicting a knife-wielding aggressor in a self-defense murder case as a passive victim 3 times, not once, but not twice, but thrice. That's powerful. And I think that just needs to be nipped in the bud, especially where it's just so unnecessary for the jury's comprehension of the case. And of course, and I think, and again, any value of the limiting instruction was greatly minimized with the exchange of the prosecutor and the officer. And this is quoted in my brief, but she concludes with, question, do you believe it will assist the jury in determining what your opinion is of how the scene occurred? Answer, I do. I didn't read the full exchange. It's in my brief since I'm running out of time. Well, and again, I thank the court for the opportunity to be heard.
Thank you, counsel.
Thank you.
Thank you, Presiding Judge. May it please the court, Mr. Dunbar, Mr. Pugh. The state's position, Mr. Probst, the state's position very simply is that this is essentially a diagram or the functional equivalent of a diagram. And courts have allowed the use of diagrams to illustrate the testimony of a witness, both a lay or expert witness, for at least 50 years, probably longer. 50 years is just the opinion that's cited in the brief. We allow lay witnesses to draw where they're standing on an easel or where something occurred on a map. And we allow expert witnesses to show a diagram that illustrates their opinion. And we've been calling this, and I'm guilty of the same thing, we've been calling it a recreation or reenactment, but I think that's actually giving the animation a little more credit than it's due. It's what it essentially is a diagram of the opinion of an expert. There are some complicated mathematics and data that went into the creation of that animation, but it's really just a diagram illustrating expert testimony. The recreation occurred in the mind of the expert and in his testimony. The animation is just a tool to help him explain it. And the defense and defendant have discussed the Hamilton and Lewis case, which quotes Miller, which quotes Lopez in turn, going all the way back into the trial. Their original objection was language that originally came from that Lopez case, saying that any staged recreation involving human beings are impossible to duplicate in every minute detail and are therefore inherently dangerous. And that particular language has been handed down from case to case, from Lopez to Miller on down. But if you go back to Miller and actually look, when they say replicating human beings, they mean actual human beings and actual human reenactment. And that's what Lopez was. Lopez involved a marijuana buy in a hotel parking lot, and police made a videotaped recreation of it using actual human beings and human actors to show the jury. And that recreation differed substantially from the testimony of the witnesses. There were a different number of cars in the parking lot, possibly a different time of day. Cars were driving around the parking lot, no indication that they were driving in the same manner that they were driven at the time of the offense. It showed the motel from one angle. No testimony of any one witness viewed the scene from that angle. So there's an element of artificiality introduced right there. And it showed human actors with human gestures and impressions. Basically, police used actors in a staged performance and made an episode of Unsolved Mysteries or America's Most Wanted and showed it to the jury and said, this is what we want you to believe happened. And there's a reason why those recreations always say artist's recreation or video reenactment.
Were the injuries to the defendant in the video accurate to the actual testimony about what the injuries were? I mean, I see the guy and he sort of generally responds to physics, but then he gets under, I see that he gets under one side of the car, which is what the accident is trying to show, is that where he's hit by the car, but then it runs him over. Does it accurately reflect the theory about how those injuries occurred to the defendant or to the victim?
Yes, it does. It was based on the testimony of the opinion of the medical examiner, who stated that the person was run over, dragged for a length of no longer than about 10 feet, because the injuries to the body show that it would have been more gruesome had it been dragged for a further length. His DNA was found under the center of the car, and there were crush injuries that showed that he was injured in the manner that he was depicted being run over.
So having a body serves a purpose, as opposed to an X or even a stick figure. It serves a purpose to elicit or to explain some of the test, or to visualize some of the testimony, explain some of the testimony.
Yes, I think that's exactly right. That it depicts what the expert said more accurately than just something showing that, like you say, just an X, etc.
But didn't Judge Edson?
Blood or anything.
Go ahead. I'm sorry.
It wasn't gruesome. The last point, I'm sorry, Judge Geezer. It wasn't, there's no blood on the scene. There's no anything like that. It just shows the way the accident occurs.
That's correct. It's not gruesome in any manner as far as gore or blood or something that would make it prejudicial, unduly prejudicial. It's simply showing where the person was when he was struck and how the vehicle ran him over, and the distance from the point that the vehicle originally began accelerating. There's no attempt to show the jury. There's no attempt to recreate, for example, the medical examiner's photographs of the body. It's just to depict the physics of the car.
Was there any objection by the defense to either the science or the software in the case?
No, there was not. The objection of the defense, they never objected to the credentials of the witnesses. They never challenged him as an expert witness, and they never challenged the science or anything involving the animation. The only objection was to the prejudicial effect of the animation. And it's our opinion that the animation was simply an expression of that expert's opinion. So if you haven't objected to the expert's opinion, then there's not much to object to about the animation, because that's simply demonstrating that expert's opinion, which has already come in without objection.
Well, didn't Judge Edson in the hearing outside the presence of the jury deciding whether or not this evidence was admissible, didn't he find that the evidence had some value, at least, in helping the jury understand the facts of the case? Didn't he make that specific finding? And isn't that within his discretion? Now, aren't we supposed to defer to it?
Absolutely, Your Honor. And I do have to point out that actually this is Judge Edson's court, but for whatever reason that a visiting judge, it was actually Judge Frank Griffin that heard this particular case. I'm not certain of the reason. It may have been conflict because of a district attorney, but just for the court's information, that was Judge Griffin. But yes, you're exactly correct. He did find that there was that it did have probative value, and that other than the first person video, which appeared to show what the defendant would have seen from the inside of his vehicle. Yeah. And he said that was going a little bit too far. And I think that was probably appropriate, because I think that could have led the jury to think this is exactly what the person saw when they were driving.
So this was Judge Griffin. I know the papers there, the PDR and whatever, listed Judge Edson, but he's just the judge of the court.
That's correct, Your Honor.
And it was a visiting judge.
He's the presiding judge of the particular court, but Judge Griffin actually heard the case.
Mr. Lindsay, is there anything in the record to show or demonstrate how much notice the defense had that this particular video was coming?
I'm not 100% certain, but I do know that just from personal information that the video takes a long time to create, and that we had to research the Murphy and Castanon, et cetera, cases far in advance. So it's my understanding that they were given the video far in advance. I could look that information up, but there was no indication that this was sprung on the jury. They didn't, or sprung on the defense counsel at the last moment. It's my understanding that there was plenty of information, at least a month ahead of time, that they were notified of this. And of course, they didn't ask for any sort of continuance to further examine it or create a video of their own. I think that, and I'd also note that they had done plenty of research prior to the admission of the video. They quoted in their, they quoted the Miller and Lopez case in trying to keep the video out. So they were fully aware of the video going in. There was no indication that this video was anything that was any sort of surprise to the defense. And going into Miller, just briefly, the Miller case that relied on the Lopez case, the problem again with the Lopez case was it was recounting actual human beings. In Miller, there was no danger of showing actual humans with human gesticulations, and it was tied to the testimony of a witness that the witness, the co-defendant said, this is the route we took, gave names of streets, descriptions of traffic, used a map and a diagram. So it actually demonstrated the testimony of a witness. So he authenticated that video, and there weren't the same problems with it as there were in Lopez. And so Miller didn't show human actors and human gesticulations. Matching the testimony of a witness is all that was needed. Now, the Texas cases that do show the admission of an animations of abuse of discretion, and both parties have quoted them, are the lower court Hamilton's and Evans cases. And the animation there was very different than in the instant case, and there were multiple reasons for its exclusion. It wasn't made by a witness with personal knowledge, which is the same as in Lopez. It didn't accurately demonstrate the testimony of any witness. It wasn't an admissible lay opinion, and it didn't demonstrate an expert opinion. Lewis pointed out, and he used some language from the Stephen Good Law Review article that I think is really helpful, that a computer animation is just a series of images demonstrated by a computer serving as demonstrative evidence. It illustrates what a witness saw or demonstrates general principles underlying an expert opinion, or depicts an expert's theory of how an accident occurred. And if the evidence is authenticated by a witness's testimony, then it's a fair and accurate depiction. And if not, it's not admissible. And that was the problem with the animation in the Evans case, which is not present in the instant case, that none of those factors were present. It was a 120-second animation of a multi-person shootout that was made by a police officer who was not testifying as an expert and did not have personal knowledge of what was in the video. Essentially, it was 4 people running around in a shootout using times that did not match the testimony of any witness, running in directions that didn't match the testimony of any witness. What testimony it did match were showing a different elevation than her apartment was at. The gunshots were different because it was based not on the witness's testimony, but on the number of cartridges, shells that were found at the scene. And it was, the court said that it was pure speculation, that it was basically the same as in Lopez. It was, this is what we want the jury to think happened based on our investigation. And that's not a witness's testimony. That's not an expert's testimony. That's simply an animation created by police showing what their non-expert opinion is. It wasn't based on any quantifiable data because it wasn't an expert opinion. By contrast, the cases involving accident reconstruction cited in our brief, the Mendoza and Murphy cases, Castanon cases, all involve accident reconstructionists that were certified as experts in those courts. I'd also point out really quickly that the objections in Hamilton and Lewis weren't exactly the same as in the instant case. They weren't 401, 402, 403 objections. They were objections under Rule of Evidence 602 and 701. And there were very specific reasons in those rules for keeping that out involving non-expert testimony. And I'm kicking myself for Rule 602. I did not quote the entire rule in my brief, and I can't tell you exactly why. But it refers to need for personal knowledge, that a witness must have personal knowledge of the matter, which may consist of their own testimony, but does not apply to a witness's expert testimony under Rule 703. And automatically this takes, the instant case is taken out of that equation because this involved expert testimony. Rule 701 is opinion testimony by lay witnesses. And again, that doesn't apply in the instant case because the witness here was testifying as an expert. Long story short, it was not used to illustrate expert testimony. There was no expert, no acceleration marks, no accelerometers, no marks on a vehicle to show where a body hit. It was a bunch of people chaotically running around, no DNA. Speculation on some of what a witness told a non-expert officer.
Counsel?
I'm sorry?
Just to make sure I understand correctly, basically you're saying that the where we have demonstrative exhibits that go off the beam or go off the rails, it's because there's a bunch of extraneous detail that is included that's not tied to the evidence.
Yes, I think that's a fair statement. That if also we have to look at the difference between a lay witness's testimony and an expert testimony. That the expert testimony is he's testifying from data that an expert can testify to things that are outside of his personal knowledge. It's the same for in an insanity case where an expert could testify without actually cross-examining witnesses as far as whether a person was insane at the time of an offense, and we allow that. It's in the instant case, some of the measurements were made by another accident reconstruction specialist, but that's fine in an expert testimony case, as long as there is quantifiable data. Yes, I'm sorry, Judge Richardson, I thought you had a question.
No, just clear my throat, sorry.
I do have
Yes,
a question. Did the state contest the claim that the victim had a knife in his hand?
In his hand, yes. Well, we didn't contest it. There just wasn't any evidence outside of the defendant's testimony to show that. He had been shown wielding a knife in the bar earlier, and he had one in his possession, and he had one beside him at the time that he was run over. But
that was not a contested issue?
It wasn't. I'm trying to think of exactly how to word this. We did not admit the defendant's that the evidence supported the defendant's claim of what he said. There wasn't any evidence that he had it in his hand, other than.
It leads me to be the question about whether the possession of the knife is contested leads me to wonder whether if the shoe were on the other foot and it was the defense who had called an expert to put on an animation demonstrating, you know, the figure of the person holding a knife while he was, you know, being assaulted by the vehicle, would the state have had a problem with that? Would the state have objected?
I think the issue of him having a knife or not having a knife, I think that he should have been depicted not having a knife under either circumstance. The reason being that that figure was not intended to represent what Mr. Delorme was doing at the time. It wasn't intended to look like him, behave like him. It was showing what his position was, where he was struck, and when he was found. And it wasn't attempting to get into proving or disproving an expert opinion, his testimony. It was showing Mr. Delorme was here.
I understand what you're suggesting that the state intended to accomplish by admitting the video that was admitted in this case, but I'm asking you to consider if it wasn't the state who was offering it, if it was the defense who had put together an animation to show essentially kind of the same sort of factual scenario, but had done so by creating that figure of the victim holding a knife in his hand. Would that have been objectionable to the state?
I think we would have not objected to it just out of an abundance of caution, because that was the victim's testimony, or I'm sorry, the defendant's testimony. As far as whether or not it would have been objectionable and would have been sustainable, quite possibly, but I think we probably would have allowed the defendant to have put that in, simply because that was illustrating what he wanted to illustrate. But other than the defendant's own testimony, there was no indication that he was wielding a knife, standing alongside the car, attacking him. All of the physical evidence showed that he was 85 feet away from the car. The car accelerated directly towards him and kept accelerating until it struck him, and that it ran him over, and a knife was found next to him afterwards. And that was the only purpose of showing the video, was to show the distance away that he began accelerating and where he was struck. And if it accomplished that, the expert said that this is an accurate representation of my opinion, then it's authenticated, and that it's not unduly prejudicial because it's just a replication of what the expert has already testified to.
Did the state offer testimony that the knife was found near the defendant? And did these experts do that? Did these experts that you're relying on to introduce the demonstrative aid to highlight or enhance their testimony, did those experts say a knife was found?
The experts did not testify to that because they were only testifying as to the position of the vehicle, the buildings, and Mr. Delorme. But the crime scene photographs that were taken do clearly show a knife next to Mr. Delorme. Now, whether he had it in his pocket or sheathed or was holding it or wielding it. Now, again, bear in mind, he would have been, even had he been threatening the vehicle with it, he would have been threatening from 85 feet away. So we don't believe that that's really indicative of anything one way or the other. He's entitled to a self-defense instruction on his testimony alone, but under these facts, I don't see how that physical evidence could have indicated that a jury could have found self-defense. It's, yes, there was evidence that he was holding a knife.
If the knife, is it possible for a knife to be capable of causing deadly bodily injury to a car that's 80 feet away?
No, unless you are a very expert knife thrower that can throw through a windshield. Like, it's just not.
Like a ninja.
Like a ninja, yes, Your Honor.
Thank you, counsel. Your time is up.
Thank you, Judge.
Thank you, honorable judges. I'm going to use a word that gets overused, but it's certainly appropriate here, and I can't think of a better way to describe it. This is a very slippery slope that we're opening up if we allow either party, the defense or the state, to bring in animations that depict human behavior. I've listened to all of the arguments so far and the questions from the judges. I want to clarify that, of course, we do have a vehicle here where there is some accident reconstruction involved, and we've seen those in the cases. But there's a reason that all the cases that are relied on by the state involve two vehicles and not any pedestrians or any humans outside of vehicles, because that would flatly contradict what we have in Miller. I realize that Miller is arguably dicta, but it's very powerful dicta. It talks about the right to a fair trial, and it talks about almost the impossibility of having a depiction of a human and a human's behavior without creating problems that could undermine a fair trial.
Well, can I ask a question?
Yes, sir.
Now, what if, and I don't know honestly, what I'm going to discover when I look at this more closely in the record, maybe you can inform me, but if the defense is given, a fair opportunity to, in terms of time and notice, to produce a competing video that would essentially, play the same role as competing testimony, since, one side is bringing in video, The other side ought to be able to bring in a video, and the jury can ultimately decide who's telling the truth. Under a circumstance like that, why would we be worried about something like this?
So I think that's a great question. Mr. Dunbar and I did not try the case, so we weren't involved at that stage. But certainly, one of the things that a skilled and zealous advocate would do at trial is to say, well, Your Honor, if they're going to have a video animation, I'd like to have my own expert to do a video animation. And I don't know what grounds we could have to deny that. I mean, we're supposed to have a fairly level playing field, at least in what gets to be presented. What would the defense video look like in this case? I mean, our argument would be, well, he's not standing still with a knife from 85 feet away, just, motionless there. He's in fact doing something more like what the defendant describes, which is coming at him with a knife. How creative would we be allowed to be if we were doing that at trial as the defense team? Does he get to run at the car? Does he have a knife up like this? Certainly all that, having a knife in his hand is certainly consistent with the photographs produced by the state that show a knife sort of past his body, and I believe, if I'm not mistaken, kind of with an outstretched arm pointing in that direction. So we would get into a sort of dueling animations contest. And it's not about what the vehicle's doing so much, it's about what the human is doing. And some of this gets into the idea of harm analysis, and I know we're really not there at this point, but it's a self-defense case. In a self-defense case, one of the critical issues is the behavior of the decedent when the person is deceased.
Well, this is a 403. We're talking about an objection based upon the substantially more prejudicial than probative rule, right? And that rule contains it uses the word unfair prejudice, right? Not just prejudice, but unfair. And so, that's the thing, honestly, that has me asking these questions about the fairness of the process involved in presenting a video of this nature. So anyway, if that helps you, I don't know if it does.
Also, are you complaining about the science and the software, or just that because obviously the evidence that came in through the witnesses about the decedent and the knife did come in. It didn't come in through a video, but it did come in. So is it the science and the software you're complaining about?
Well, Your Honor, I think that the time to complain about that would have been in the trial court, through an objection or through a counter expert. However, I think we can say, even standing here with the record that we've got, I think we can say that it's just not very hard, using common sense and our understanding of how things work in the world, that this could have happened differently than what the science, we've got one accident reconstructionist recreating this in a parking lot, not the same parking lot, but years later in a parking lot that he deemed similar. You've got, I think, 3 people involved in measuring marks, taking photographs. It was all very piecemeal. One of them would, go to a parking lot and take some experiments on gravel disbursement, and another one saw the truck. They didn't both do the same thing. So I think that's certainly questionable, but it's not challenged in the record.
Counsel, I know you're out of time. I wanted to just follow up really quickly. Do all defendants have the same ability to engage in the competing demonstration exhibits that is envisioned here or has been discussed?
Well, certainly not without the court's assistance. In Taylor County, where this case was tried, there's about 70% of all cases are indigent. So it would take substantial money from the taxpayers to make that happen.
Right.
Thank you, counsel. Your time is up.
Thank you.
The case is submitted. The court will stand in recess until 11 o'clock.